Speaking about licenses, there's an email that I have. I don't know if any of you have gotten. If not, I can provide a copy. It's a paper about an incident that happened in Dan Meter's life. I don't want to discuss what Dan Meter is. If you don't know who he is, we'll talk about it later. But Dan Meter went to a party of lawyers. And as usual, they asked him what he thought could be done to improve the lot of lawyers and how they're being maligned to the public. And several times Dan said, you really don't want to ask me that kind of question because I'll give you an answer. Oh no, we really want to know, we really want to know. Did anybody hear this?
Yes.
Okay.
I did.
The issue is that he's turned around and he said, well, the point is I don't know whether you're a good lawyer or a bad lawyer. So if you ask me what I would do is this. I would have a book, and every lawyer, every time he had a complaint filed against him, his name would go in the book. And if his name went in the book 3 times, that name would be put on a ping pong ball and put into one of those hoppers like you have for the lottery. And every month we'd pull out 10 names. And we'd issue licenses to kill the 10 names that were pulled out of the book. And we'd give it to the people who issued the complaint. Now those people, if they were really ticked enough, they could seek redress of grievances Colt 45 style. Or what they could do is sell the license to collect money to pay back for their damages. And we see this as a win-win situation. Now for the lawyers that are involved, it's really very simple. If you have 2 complaints against you, and your name is in the book 2 times, quit. He ruined the party. So my issue is this. As far as I'm concerned, I looked at this as a perfect solution to a problem. And I have to tell you that there were several people that I talked to that were horrified at this. Because they were talking about you can't kill people. And I say, why not? Lawyers do it every day. Well, you have a lousy attitude. Okay.
So, want to play lottery?
All right. Second point. Pact is having a problem. There are a lot of people who have not paid their memberships. And there are a couple in here that are in there. I'm not going to maintain names, I'm not going to embarrass anybody. But the point is this. If I'd like to have your memberships up to date, and to the extent possible, we have several expenses that we need money to cover them. As you're aware, we do not have fundraisers, we do not have corporate sponsors. Every dollar that we spend comes out of us. And one of the things that I keep trying to point out, we don't want a large donation from a single person. We want to keep it small donations from everybody. This way everybody's involved, everybody has an axe to grind. Everybody has a reason to support what we're doing. Last, I am very concerned about the fringe of people who are coming through these meetings. They come to the meeting and they hear some magic words. Now most of you here know that magic words don't work in a courtroom. You've had specific reasons, painful experience to show that it doesn't work. But several people have come out of these meetings and then gone into the courtroom and tried to use what they've learned here. The very worst case is somebody who actually walked into the court and said he was a Pact member, which he wasn't, and expected the judge to do something about it. The judge did. He asked him some basic questions, realized the guy didn't know anything, and hung him. Now there have been no less than 4, at least 4 that I can think of right now, or 5 people who have been indicted over the past year. Those people who have been indicted have all done some basic things wrong. things that we've already talked about in this meeting. We had a conversation several months ago about somebody who was indicted and what that person did wrong. And when that person found out about it, his only question was, why didn't I get his permission to talk about his case? Okay. I didn't ask his permission. And my reason for not doing it is very simple. It's public knowledge. The question for you is whether or not you understand you have a choice. The choice is you can learn or you can be railroaded. You cannot walk into a courtroom and ask for a 4-month hiatus or adjournment so you can go to Pact and learn how to beat the crap out of him. It doesn't work. We just had a case this past week where somebody who's been afraid of an indictment for about 6 months has written back that he's gotten information that the indictment has come down and he will be served imminently. He's looking for help. We have tried to give him the help. We've tried to give him the information to be done. Specifically, and this is the thing that really upsets me, he's gotten some information on what to do with the indictments, or the potential indictments. And the first issue, can anyone tell me, not you, Jim, because you already know, can anyone tell me what's the first thing that this guy should have done? Anybody?
The man to be present at the grand jury.
This is getting scary.
Most
it's starting to work.
Most of the objections to the grand jury. Squash the grand jury.
Yeah. Squash the
Well, you don't
squash the indictment.
Yeah, if you go to the grand jury, you can stop it. And the point is, it's starting to work. That's rewarding. I'm very pleased with that. The issue is, if you don't go, the grand jury is going to have one side of the story and not the other side. Now, as long as we've gone that far, and as long as I'm on a roll, and let's assume that you're not at the grand jury, make it easy, keep it simple. What are they going to do wrong without even being there? What do you know they're going to do wrong? Now, I want one answer from each person. Raise your hands if you want to respond. Okay.
Well, you're not allowed to have a lawyer there if you were going to be present. The state has a lawyer. Hey, what I think, you got to compensate me for that. I work hard to look this good. You can't have they can't have a lawyer there. In other words, the prosecutor can't be there then. Okay. Only your accuser.
All right. The thing is that I would rather you be a little more clear, because you know what you're doing.
Yeah, I'll answer that.
Is that if your counsel can't be there, then counsel for the prosecution can't be there. So your opposing party can't be there either. Okay. Let's assume that I'm prosecutor John Smith, but I'm not going to be the prosecutor in your case. Can I be there?
No lawyers are allowed.
No, he can be there outside.
No, we can't be there. Object to his being there.
Oh, in the courtroom, yeah.
In other words, in the grand jury, you have to object to anyone who shouldn't be there.
Grand jury is private. It's not for the general public.
Right, but the jury foreman of the grand juries will supposed to ask the questions, not the prosecutor, right?
Okay, you're confusing. Yes, we're getting too many things at one time. First of all, the grand jury meeting room is not open to the public, but it is available to all interested parties. Now, from my own experience, I allowed them to keep me out until it was my turn to testify. That will not happen again.
There's an issue there. If you're testifying as a witness,
yes,
they don't want your position to be slanted by anything that, in fact, other people say.
Yes.
So one of the things that anyone here must do, I can't get in front of there, must do is say, I want to be the first witness because I want to see when other people testify that they're allowed to lie with impunity. And the only way you can do that is by testifying first. Recognize if a judge in a regular hearing knows that you're going to be a witness, she's going to put off you testifying because that judge, if the judge knows she's going to do something or he's going to do something wrong, never wants you in there.
Okay. Is there any other question about what Erwin said? Go ahead.
I have a question. Why does being first as opposed to being last deter lying?
Well, if you're the first one, you can then remain. And if in fact you see someone else testifying falsely, you go to the foreman of the grand jury.
Well,
and you say, he's lied.
Now you object out in the open, or you...
You write a letter or a note to the foreman, you're saying, you have information, your information and belief, he's lied, and you believe he should be prosecuted for perjury.
Excuse me. You believe that the foreman of the grand jury should sign a complaint so that he should be prosecuted for perjury.
So why shouldn't we prosecute you for perjury? How do we know you're not lying?
Again, this is...
That's fine. The issue is this. Once you have that, you now have a material fact and dispute. Let's try him, and if I've committed perjury, we can then have prosecuted me. But right now, I've prosecuted him.
Oh, okay, I see what you're saying.
It's almost like the waiver.
You're putting yourself in a position where you can bring a prosecution against the witness.
Realize
it's the whole thing of indicting a grapefruit. The point is, they use it against us all the time. Why can't we use it against them?
Marty, you raised the issue that police must effectively sign a waiver of immunity.
I raised it. It was actually done in my case.
In a grand jury. What that means is the police have to sign something saying, to my knowledge and belief, I'm going to tell the truth because
I know it to be.
Because they then can be prosecuted if someone says, I know they're lying.
I heard the lawyer in that case say some of them signed it, or maybe you told me, pardon me, my memory's not exact. You told me that some of them signed it, some of them didn't.
Not true. They all signed.
They all signed? The ones that testified all signed. Is that true?
And the point is that they all the witnesses on the list, which is more than one to testify. They all signed. The ones who were on the witness list, whether they testified or not, all signed.
They did all sign. Oh, okay.
That's according to the transcript that we got.
Oh, okay. My mistake.
But they still haven't found those waivers.
They still haven't found a waiver.
They haven't produced them at any rate.
All right? Now, let's not play with them.
Okay, no, I'm good.
Now, the last issue with regard to meetings. This is serious, because I've got to make an immediate decision about this so that it affects next month's newsletter. Back up. The newsletter is done. It has not been printed yet. It's a logistical matter. Since I'm involved, I'm apologizing for the editorial staff. We will get it out, and it will be mailed out shortly. That's the best that I can do today. I don't have a fixed date, but it will be done shortly. In the meantime, as far as the newsletter is concerned, we have to make an immediate kind of decision. I brought this up 5 months ago, and I did not get any kind of response on it. February and March of next year, our meeting dates here are taken by American Legion Business. So we have several choices. Choice number one is to have a meeting on a different night.
Turn this on.
Now the different night can be a different week. I want to raise with regard to in addition to the 5 people who were indicted, there are probably 5 or 6 other people who have not followed Pact's recommendations with regard to their own cases. Now, from my perspective, especially thinking that you understand what we're talking about, I really am concerned by the fact that these people work so poorly in their own cases. We had a gentleman who 3 weeks ago went to court in Pennsylvania and spent quite a bit of time preparing for his case. and then use none of it in his own case. There are several issues with regard to him and what happened afterwards, which I don't want on that tape, so I'm not going to go into them. But the bottom line to it is that he was sentenced to 6 months in jail. As a result of this, I'm still trying to find out how he can be sentenced in a civil manner. And I still don't understand that. I can't get a hold of him, so I don't know. So if any of you know who it is, and it's not a secret, and can contact him, I'm specifically looking for details as to how this happened. And what's more important, why he allowed it to happen. From my own perspective, if you have any reason why you would not use the Pact material in your own case, the time to bring that up is now. Or as soon as you make the decision to not use it. Because otherwise, we're going along thinking that when you walk into that courtroom, you're going to be the master of all you survey. And obviously, these people were not. Which leads to the last part of this. I have a personal pet peeve. This was best personified by somebody who is involved in a criminal case in New York. And he came to Pact for help. We assisted him in preparing for his case, including helping him write his papers and so on. Once he was finished, he came up and talked about doing what's called an omnibus motion.
What is that?
An omnibus motion, which is some kind of a catch-all phrase for what they do in New York.
It's a discovery motion.
We do not, for those of you that can't say it automatically, we do not recommend using omnibus motions for anything. What's more important, though, is that I saw the papers that he prepared after he was told not to. And we're sitting there challenging the jurisdiction of the court, specifically stating that we refuse to be identified as defendant until jurisdiction is established.
What state? What state?
And in the paper that he filed after us, he identified himself as so-and-so, I'm a defendant.
What are you suggesting? In other words, first of all, don't identify yourself as a defendant, because you're not.
The point is, if you're going to change what we're doing, please tell us before you do it. Telling us after you file papers indicating what you're doing is the wrong time. I filed a paper confessing to doing something wrong. And now they're going to prosecute me for doing that. Can you help me? No. Once you file a confession, unless you can plead some form of insanity or something like that, which is probably true, there's very little that we can do. And the important thing is this. If you're asking for our help, you have an obligation. If you don't like what you hear, we're the first people you should tell.
How can I end up telling you without causing any problem with the group with what's been going on in my case, and I'm still fighting it, but I know I'm not going to win because I don't have all the knowledge.
Because you're not going to, you want a specific detail in your case. That's not what this meeting is for.
Okay.
That's the first issue. The second issue is what goes on is a question of argument, which does nobody any good. Remember, the people in this room, some come 3 hours each way to come here. They don't need to get involved in the very minute details of your case. There are some parts of the generic side of it that are of interest to everybody. And if they don't hear it from you directly, they can hear about it in presentation at the next meeting. But the only one that has an interest of those details is you.
Morning?
Yeah, go ahead.
Okay. There are certain things that happen to all of us in court. And I think one of the issues is, what do you do when a lawyer lies?
Okay.
And, you know, the question is, if you can show it specifically to individuals, how do you ensure that that judge who has a duty and responsibility either reports, sanctions, or in fact begins a prosecution of that attorney for lying?
Okay. This is detail. I don't want to do this now. But this is an important part of it, which is what I call courtroom demeanor, courtroom conduct. First of all, we do not challenge authority effectively. And you have to learn how to do that. If you allow them to get away with saying, I'm not going to follow the rules, then why are you there? Why are you staying in that room? The better question is, if they don't have to follow the rules, why do you? Now, if we're going to consider perjury as lawful evidence in this case, then what other things can I do to defend it? We have a member who suggested trial by combat as a perfectly valid solution and used it in court. This is not a joke. I'm very serious. And when he used it against the lawyer, on the opposing lawyer, I thought he was going to have a heart attack. But the point is this. Once we assume the rules don't count, all bets are off. And Pact truly believes that none of the rules count. Can anybody tell me why? Raise your hand.
Because rules aren't a law.
You didn't raise your hand.
I'm recalcitrant, what can I tell you?
Excuse me. What did he just do?
He didn't follow the rules.
And what did I just say before that?
They don't expect you to do.
Do you see how it works? Do you see how it's effective if it works? The point of the matter is this. I wouldn't expect him to follow the rules anyway. He's a kid. He's not smart enough to understand them. But you see, you people are laughing at the wrong joke. Only the people that understand them go to jail.
But you also have to say, I don't understand them, because then, if you don't, the assumption is you do.
Now, can anybody tell me what an assumption really is?
Making an ass of you and me.
I know that, but ignoring that. What is an assumption? Anybody?
Something that hasn't been denied?
No.
An admission of guilt?
No.
Your best guess.
Someone else's
Statutory term for
An assumption is my belief of truth without any substantiation for that belief. So I believe that our learned guest over here really knows what he's talking about. Unfortunately, most of the time he opens his mouth and proves me wrong. The important thing, though, is that as long as I have this assumption, many of these assumptions are going to hurt me or going to hurt you unless I tell you about them and let you rebut them. You're going to be in trouble. Now, we all know the courts have presumptions against all of us when we go to court. How do you negate those presumptions?
If they're articulated, naturally object.
They're not articulated.
Sometimes they are.
Not articulated.
You're talking about the ones that are not articulated? Okay.
The important ones aren't articulated.
Okay.
Read the assertion of rights.
Not good enough. Yes, that's a first step, but it's not good enough.
Ask that all the presumptions be explained to you.
Okay.
Well, that's in the assertion.
Ask if there's any presumption.
Right. That's what they both saying. The point is this. Are there any presumptions going to be used against me? And the judge says, of course there are. We presume you're innocent.
why are we here?
Are there any other?
That's the thing that nobody does.
What's that? I didn't hear that.
You see? This is the problem. That's the most important thing we heard today.
Then why are we here?
What are the others? Are there any others? When are you done?
You're never done.
Yes, you are. Yes, you are.
When you can walk out.
Before that. You're done when the judge says there are no other presumptions in this case. Until you have that, you got nothing.
You're making an assumption.
That
And your assumption is that he's going to tell you all of what he's going to presume.
No, the point is that once you have the presumptions on the record and him saying there aren't any more, then you have the information you need to justify his decision-making process.
How many times have you gotten a judge to say, these are all my presumptions?
I've only used it once, and the judge, very shortly after I forced him to continue with the presumption issue, dismissed the case. So I don't know. But all I'm going to tell you is that once you have the assumptions down, you now have his ground rules. And that's what you want.
And what I'm suggesting is, you're never going to get the ground rules down because they're going to change them.
Agreed. And as soon as he does, it's no longer part of this case.
Fine, but as soon as he does, you didn't say that as a presumption.
That's correct.
Why were you lying to me?
Something went off over here. I think it's yours.
Or why did you misstate
Absolutely correct.
material facts that impact me? I can't understand it.
All I'm saying is you've got to get these things down. And to the extent that you get them down and you get the admission that these are all of them, there are no more, you now have grounds for everything up to and including mistrial.
And what do you do if he doesn't want to put presumptions on?
Then I want a statement saying that, are you saying there are presumptions you don't want to tell me?
He'll say they're in these book of rules. Have you read the books of rules?
No.
They don't know.
Why would I
Fine, they apply.
Excuse me.
And before you come into this courtroom, read this book, because these are the rules that I frequently follow.
That isn't good enough.
Fine, I'll leave them on and I'll come back after I read them.
Guard,
See you
hold him
see you in
because
50 years.
Excuse me.
we want to hold him in a civil contempt until he's read these rules.
Excuse me. Are you saying, am I obligated to follow these rules?
In this courtroom, the rules are followed. If you don't understand them, if you don't
All of them.
excuse me, sir, I'm talking, not you.
Okay, Judge, you talk.
Are you ordering me to talk? You're being contemptuous. Do you know that?
All right. We can go on with this. I'm going to put it again. Give me what you're saying, finish it.
Okay, what I'm suggesting is if the judge doesn't place the presumptions on, you then have a duty and obligation to place them on. These are the way this court is. And in fact, it's better when you say, these are the rules that I'm following.
Yes.
Please tell me if you're going to do anything differently. Let the record reflect. These are the rules in this, my court.
Okay. Now, I'm going to give you a vote, since you volunteered, Erwin. I'm going to tell you that I only have 3 rules when I go to court. And they're in the Pact maxims. So therefore, since you volunteered, I would like you to provide by next meeting a list of the presumptions that you think that we should have when we're presenting them to the court.
I have unlimited presumptions. I presume the judge is honest. Judge, if you're going to act in a way that's not honest, I'd like to know, because I'd like that guard there, who's really an officer representing the people, to arrest you.
Now, I'm saying to you, take these presumptions, including the judicial honesty, and put them down so we can publish them.
Are you presuming that he's representing the people?
First of all, that's a very good question.
He's an officer of the court, not of the people.
Not true. The point is, as an officer of the court, if it's a public court, if it's a judicial power court, he's representing the people.
Which ones?
All of them.
Which one? All of them?
All of them.
All the people?
All the people.
The ones over in China too?
All the people in all the
All the people in this country. Now, what's this country? Anybody?
Say it again. What was the question?
What's this country?
Country of New Jersey.
Absolutely, that's what.
The
New Jersey country. That's
The
what-
Republic of New Jersey.
Is it state of or condition of?
No, you don't want to be state of, you want to be
Right.
New Jersey state.
State, right.
The important thing is that it's, first of all, if it's a federal matter, it's a federal venue, not a state venue. As we found out from the Florida idiocy, federal jurisdiction is its own question mark. And what they really tried to do was to establish that there was no federal jurisdiction. Had they stayed there, they probably would have been better off. Because by what the Supreme Court did, they established that they break jurisdiction as well. At which point their own standards, as shown by Cohens versus Virginia, states that a judge who assumes jurisdiction that he doesn't have, or fails to take jurisdiction that he does have, commits treason to the Constitution. Now,
Have you ever had that enforced? How frequently is that enforced?
I've never had the opportunity to do it. Again, I'll remember we're talking about what I know now versus what I knew before.